Supreme Court will hear a case Tuesday that could disrupt the Justice Department's sprawling investigation into the January 6th attack on the Capitol. Justices will consider if the Department of Justice went too far when it prosecuted hundreds of rioters on charges of obstruction of an official proceeding. Of the nearly 1,400 January 6th defendants, more than 350 of them have faced the obstruction charge. At least 58 of those defendants have already pleaded guilty. Let us bring in now CBS News congressional correspondent Scott MacFarlane to help us understand all of this. Scott, walk us through again the stakes here. How could this single issue affect these Justice Department cases, this broader look into January 6th?
This is a pivotal moment in what has become the largest criminal prosecution in U.S. history, John. They're going to weigh whether to strike down this obstruction of an official proceeding charge, which is not a trivial charge, John. It's been filed, as you say, in one of every 3 cases from the U.S. Capitol riot, and a whole bunch of dominoes could collapse if the high court strikes this down after arguments tomorrow, before they're done issuing their orders at the end of June. Prosecutors have argued with great success that the rioters obstructed the official electoral count on January 6th. That was the official proceeding. But some of the defendants have argued, successfully enough to get this before the high court, that that's not an appropriate charge, that this official proceeding obstruction charge was brought about after the Enron scandal in 2002 and is a crime of finance or document destruction, not a riotous mob attack. Of course, it's not trivial here, John. Donald Trump also faces that charge. He's pleaded not guilty to it in the special counsel probe of the 2020 election conspiracy case. If they strike down this charge, it could also complicate the special counsel prosecution, delaying it or shrinking it.
Fascinating. So essentially a spreadsheet crime is the argument or the defense, not an actual physical crime. If the Supreme Court goes forward and agrees with that notion that this law only applies to kind of crimes of numbers, not of physical activity, what happens to those 58 who've already pleaded guilty?
Well, they've already started adjusting some of these cases just because the Supreme Court took up the matter. For example, you'll recall the man who paraded that Confederate flag through the Capitol on January 6th. He's appealed his case already. He was convicted, citing this Supreme Court argument. And in anticipation of the Supreme Court argument, the judge has already ordered that man released pending the disposition of the Supreme Court case. So not only, John, does this hold the prospect and the promise of potentially reducing prison sentences of those who pleaded guilty, those who've been sentenced, but it's already disrupting the cases that are in the pipeline. It's going to delay future sentencings. It's going to delay the completion of other prosecutions just because the Supreme Court's taking this up. If they rule against the charge and strike it down, a whole lot of defendants are going to get out of prison a whole lot earlier.
And now back to the biggest thing in the pipeline, which you already mentioned before, which is the former president is charged under this. What is there any special particularities with his charge and whether that would go forward that would be different from what you just explained?
Yeah, of course, his case is unique, not just because it's a former president, but obviously he was not here amid the mob on January 6th. There are peculiarities and differences to his case that are somewhat obvious. There were documents in his case, the alleged fake electors that were submitted to Congress on January 6th. So there's a difference there that the special counsel thinks will hold up even if those other January 6 charges get knocked down against the other defendants. But to put it charitably, this holds the prospect of delaying the January 6 Trump case even more. It's already on the precipice of collapsing until after the 2024 election.
Can you remind us, Scott, about that timeline? So we've got a Supreme Court hearing on the immunity claim. Give us a sense of where that case stands on the calendar, given that we've got an election in November.
That's the other Supreme Court matter we're watching. A week from Thursday, the last day of their arguments, they hear the Trump presidential immunity claim. There's not a broad expectation they're going to uphold Donald Trump's claim that he's immune from prosecution because he was the president. But it will take time for them to issue whatever order they issue, and that could take until June. The judge in this case, the judge handling the Trump criminal case, has said, we're going to give you a couple months after the Supreme Court ruling, after this gets back to me, to get ready for trial. Well, that sure does put trial right in the heart of September or October, and it's not a short trial. It would bleed beyond Election Day potentially, even if it started at its most efficient. And John, you got to wonder, do the prosecutors really want to start a trial of a presidential candidate that's going to not complete before the election?
And does the Attorney General want that as well? Scott MacFarlane, fantastic as always. Thank you, Scott.